Hello, everyone, and welcome back to rmohiolaw.com. I'm Alicia, and today I'm joined by Richard A. Myers. Richard, how are you?
I'm doing wonderful. And yourself?
Good, thank you. So in today's video, we are talking about estate planning. We've talked about this many times on the blog before, but we're specifically talking about the top mistakes that can be made in estate planning. So I'm gonna go ahead and turn it over to you to kind of just walk us through those mistakes.
Well, thank you, Alicia. We've spoken about the mistakes people make when they're doing Medicaid planning or Medicaid eligibility planning, but this is talking about estate planning. So the biggest one we see people make is doing nothing. Probably about 50% of America has done nothing in their estate planning. And estate planning is just a matter of putting together a written set of documents that are going to deal with the management of your assets when you're alive, when you're disabled, and when you're deceased. So those three different main time periods. We tell people, if you've done nothing, don't worry. State of Ohio has been kind enough to put together a plan for you, but it may not be the one you like. But we guarantee everyone's done estate planning, and those who haven't put it in writing, the state of Ohio's got you covered. Hopefully that scares everybody into doing some estate planning with an estate planning attorney. Believing the myth that estate planning is only for the wealthy. Estate planning is important for everyone over the age of 18. Estate planning is so much more than just putting together your will. It's also about putting together a financial power of attorney and, very importantly, a healthcare power of attorney. Once my child turns 18, I can't make decisions for them anymore. They're on their own. So if we don't have some documents put together and they've had that major illness or major accident, they have to appoint someone to be able to make decisions. So it's always very, very important to make sure that we do that for those people who are over the age of 18 and have those documents in place. So I always joke, I said, that was my loving gift to my two children who have reached majority when they reach majority. Leaving a trust unfunded. So people will go through that process of putting together a trust and then they don't retitle any assets into it. We often tell people that, some attorneys will send you home after they put together that trust binder, and they're going to send you home with homework. Well, we all know what happened in school when the teachers gave us homework and didn't watch over it, didn't get done. Well, so often people come into our office, and when those homework attorneys give them their estate plan and they come into our office, that homework is very rarely ever done. So one of the things we do that's unique at our office is we work you through that, what we call funding. We work with you, we gather the information about the assets, decide which ones will be retitled to the trust, and we do that. We make sure we also put together a pour-over will. Because when these steps aren't taken, we often tell people what you have when you go home is a very expensive book. And we want it to be a tool that helps your family. So we make sure that we get those things funded. But also, one of the ones is also looking at joint ownership with children. That often is very happy because it seems like an easy thing. It's going to make sure that asset, typically the house, is going to avoid probate and it'll go to your children at their death. The concern that exists in that is then you've now exposed your home to the creditors of your children. And we live in such a litigious society nowadays that we want to be careful about the exposure of our assets, especially when we start to expand that exposure. There's also the issue of once I give my house to my children or put my children on title, I've also just put their spouse on title. So sometimes that, again, can be much more concerning when now the in-law will have access to the assets or I'm exposed to the in-law's debts. There are ways to transfer that down to the children, sometimes using transfer on death affidavits that seem more practical for people, but we rarely, if ever, will do a joint ownership between a child and a parent just because of the society that we live in and all the litigation. So that's just a few of those mistakes we see people make when they're doing estate planning or trying to do it on their own. It makes sense, but sometimes there's some dangers they're not aware of, and we want to make sure we create an awareness to our listeners of some of those concerns and dangers.
All right, Richard. Well, thank you so much for outlining those top mistakes for us. As you said, they are very important, and they're important things just to look for because you don't want to find yourself in a bad situation. So make sure that you're reaching out to Richard and his team. You can do so by giving them a call. You can also explore the rest of this website, rmohiolaw.com, where you'll be able to learn about all of the different ways that Richard and his team can help you and check out our weekly blogs as well. Thank you so much for watching.